She's an autonomous entity, and we're pleased that he's also sacrificed his time. Now I'm handing over the reins to him, and then from there, after Martin will address you, there's going to be the question and answer session. I encourage you to engage him, and you'll find him a very pleasant person in terms of entertaining, however critical questions anyone might raise. So over to you, Rex.
Thank you, Temba. My function this evening is to introduce Martin, and also, of course, to say a few things about his project and the work that he's done on his book. And I'm going to start by quoting myself, which is not something that I enjoy doing, but on this occasion, the words that I intend to use are so appropriate to Martin and to the efforts that he makes, that I cannot think of a better way of starting the introduction. And those of you who have already read the book will have seen the foreword, which I wrote. And in the foreword, the very first sentence reads, "Martin is a very enterprising young man." That is both true and to some extent an understatement. He is not merely very enterprising, he is phenomenally enterprising. He is engaged in so many activities more or less simultaneously that it almost defies belief that he can keep up with all the things that he undertakes himself and that are imposed upon him by others. And I know that from my position on the Rule of Law Board, I do some imposition from time to time. He acts as a general factotum, a secretary. He sends out notices, he sends out correspondence. Whenever I'm in correspondence with other people on issues of importance to the Rule of Law project, I send the documentation to him for circulation to the various members of the board. And everything gets done with meticulous attention to detail and as promptly as can be. Now, when I say that Martin is phenomenally enterprising, let me just mention a few things, because a lot of it is in the book, and you will read it. But he started, and I met him first in my capacity as chairman of the Rule of Law Board. He started with the Free Market Foundation as an intern. And it was in that capacity that I met him. Because he was an intern, he did all sorts of things, as he still does today. And my interaction with him was from the position of chairman of the Rule of Law Board. He would attend our meetings, he would keep the minutes, meticulous minutes. The minutes would be sent out on time, the agenda would be done almost at his initiative. I would add one or two things to the agenda, but he would take the initiative, and this is one of the pleasures of working with Martin, because one can rely upon him to take the initiative on any issue that needs to be accomplished. Now, Martin, apart from having written this very important book, and it's very important for reasons that I'll mention in due course, has also and continues to make contributions to all manner of journals. Those of you who have seen the Free Market Foundation's newsletter, which gets sent out periodically, you will have seen his name, and you'll have seen all the innumerable articles that he's written for that publication. But beyond that, he's written innumerable articles that have been published in the daily press, weekly press, on international press, and in the media generally. Martin has also appeared on television, he's appeared on the radio, and one could almost say that he is in the process of becoming a media personality, somewhat like the Kardashians. No, not like them at all, because he brings far more value to his contribution. Martin's work on the rule of law is so important, and in particular the publication of the book is so important to our project, and he didn't set out to discuss this, certainly not with me. He may have discussed it with Dion Lowe and others, at the time when we undertook the project. But it turns out to be, I think, one of the most important things that has been done in recent years in South Africa for the purpose of promoting the rule of law as a concept. Now I say this because there is a great deal of misunderstanding, even within the legal fraternity, about the precise meaning of the rule of law. And one of the errors that is routinely made is this belief that the rule of law is the law. Well, it isn't. Much of the law, and especially in South Africa, and in the book you will note that much of the law, the given law, the statutory law, the law that is made by the politicians, is in fact in violation of the rule of law. So there you have a paradox. The law is not the rule of law. The law quite frequently violates the rule of law. The law quite frequently has to be corrected by reference to the courts in order to put right that which is wrong with the rule of law. Now, the myth of the social contract has bequeathed to us at least one important principle. And it is a principle that has been debated by legal philosophers and by jurists. And this is the conflict that is inherent in any state situation between the liberty of the individual on the one hand and the overbearing authority of the state, the coercive authority of the state on the other. And how are these two values to be reconciled? The virtue of individual liberty and the demand of the state to be obeyed. Well, the problem has exercised the minds of a great many philosophers, legal philosophers, moral philosophers, and jurists. Socrates even dealt in an oblique way with this related issue. But one might say that the rule of law has provided the very best answer to the resolution of this issue. Because what you need to resolve is how does one control the inclination of the state through its governmental agencies to act in an overbearing way, which is frequently the inclination of any government, not just the South African government now and then, but other governments around the world. They have a natural inclination for control. That's what governments do. And that is anathema to the concept of individual liberty. So the rule of law is imposed and has been imposed throughout the millennia. It's not a new thing. It's not a creature of statute. It's not something that has been created by negotiation or by kudesa. It is something that has been an inherent part of the law throughout the millennia. And I've traced it back to the year 1250 BC, the origin. And it might go back a long way beyond that. But the rule of law is said to be a principle of the natural law. And because it has this primordial authority, it is not capable of being tinkered with, and it has a very significant respect within jurists whose opinions are worthy of respect. So, what in effect is the rule of law? The rule of law is there for the purpose of governing the governors. Who is to control the actions of those who are put in control of the state? Well, that sounds like an abstract question. The answer to that is the law, but it's not the ordinary law. It's not the man-made law, it's the rule of law. The Constitution to some extent also plays that role. But the difficulty with the Constitution is that it can be tweaked, it can be amended, and we've seen that. We've seen that the present government is in the process of doing precisely that with the issue of expropriation of property without compensation. None of those things, none of those tweaks, none of those interventions can occur in respect of the rule of law. The rule of law simply is. And its function is to control the government. It is the supervening authority over the government. Now, what Martin's book has illustrated very, very comprehensively, and I think very competently, is the two issues that arise in connection with the control of government by the rule of law. The one is the laws that are actually made. how did those laws come to be made when it was so obvious to anybody who took the trouble to look at it that the principles of that legislation was not in compliance with the rule of law? It was in fact a violation of the rule of law. There are many examples in Martin's book of that precise condition. Then you say to yourself, well, if that should happen, how does the rule of law remedy the position? Well, the rule of law doesn't, but the courts and individuals, through their own volition, are the agents for the enforcement of the rule of law, and it has been done. Now, in South Africa, most enforcement takes place via the route of the Constitution, but it is a grievous error to think that the Constitution is the only way in which the errors of the legislature can be corrected. The rule of law, I think, provides a better solution, because it isn't, as I say, amended and tweaked in the way in which the Constitution can be amended and tweaked. So Martin's book also deals with the second failure. The first failure is the laws that have been made and which violate the rule of law. The second failure is the court's failure to enforce the rule of law properly or at all when matters come before it. So those two failures are of singular importance to us, and they are highlighted in Martin's book. And hopefully this book will be read by some of the lawmakers, by some of the judicial officers who take decisions on issues such as this. And note will be taken, as I'm sure it will be, if the trouble is taken to read the book, note will be taken of its contents. So in this respect, Martin has done us a very great service, not just to those who propagate the idea of the rule of law, but to the general well-being of the social political structure of the country. And with these words, I welcome Martin to the come and address.
So, thank you very much to Themba and especially to Rex for that very kind introduction. And of course, thank you to all of you for making the time to come here tonight on this very, very hot evening. I didn't expect Cape Town to welcome me in this way, but that is the case. And of course, thank you to Wayne and Yusuf from the Friedrich Naumann Foundation for hosting us. It's a great service to the Free Market Foundation and to me personally. So this is the second launch of this book. The first one was earlier this year, I think in March, in Johannesburg. So I won't be doing the exact same talk that I did then. If you want to watch that, please go to YouTube and to Facebook, where it is freely available for you to have a look at. But today I want to focus on a particular theme in the book, and that is what Rex just mentioned now. And that is how the courts in South Africa, which should be and traditionally have been regarded as the guardians of liberty and of the constitutional state, have instead taken a largely oppositional attitude towards individual freedom and to property rights specifically. But before we get into that, a general introduction and contextualization I think is necessary. What do all these people have in common other than being politicians? There are some very interesting characters in there. One of them, thankfully, is dead. Oh, sorry, I actually said that, I apologize. So they all believe in radically different worldviews. They all represent radically different organizations in radically different countries and with radically different contexts. But how can we say that they're alike other than being politicians? And that is the rule of law. The notion of the rule of law enjoys almost universal support by everyone, and indeed especially by politicians, or at least that's what they say. At some point in broad daylight, and I think to them subjectively with something approaching sincerity, all of these people have declared their support for the rule of law in some way. But this is despite the fact that arbitrariness as a condition seems to be becoming a more common phenomenon that in the way we are governed as individuals and as citizens. So it seems like the more of these people support the rule of law, the more it is actually replaced with the rule of man, which is absolutely anathema to what it's all about. So like good governance, like transparency or democracy, everyone talks about how great the rule of law is and how much they support it. I mean, every single speech by Johannesburg Mayor Herman Mashaba includes a reference to the rule of law. President Cyril Ramaphosa talks about how the rule of law will guide his expropriation of property without compensation. And of course, many judgments of the superior courts, although not enough, do include some token reference to the rule of law. So the term then seems to be empty of substantive content. At least that's the impression that I think is created by a lot of people and in the minds of most people. And I think my role in the book and here tonight is to try and dispel that genericism that exists around this concept. So what is the relevance of this to our daily lives? I think all of us realize that a measure of arbitrariness has gripped the way we are governed on a day-by-day basis. A few months ago, it was load shedding. Government published their schedules, and they didn't adhere to it. So what was the point? It was totally arbitrary. Today, one can point, for example, to how hate speech disputes are adjudicated, which I will come back to later. But at some level, I think we appreciate that these are no longer really fair hearings. There's the example of the president firing ministers. Jacob Zuma infamously fired finance minister Nhlanhla Nene in 2015 and replaced him with this random Des van Rooyen character for a weekend. And this made the rand-dollar exchange rate fall from 15 rand 59 cents to 15 rand 27 cents in only one day. Van Rooyen was then fired, as we know, and we settled again on Pravin Gordhan in I think it was the same year. And then in 2017, Gordhan was fired and replaced by another random appointment, Malusi Gigaba, leading to a downgrade by Standard & Poor. Gigaba was then fired by President Ramaphosa in 2018. And again, we had Nhlanhla Nene back. And nowadays, we have Tito Mboweni. And from my perspective, it's a circus, not unlike Donald Trump's administration in the United States. Although their economy doesn't suffer as much because government isn't quite as involved in the economy there as it is here. So Gordhan told the State Capture Commission that the firing of Nene cost the economy about 500 billion rand, mainly due to the decreased market value of financial and property shares as well as bonds. So there is no real justification for any of these actions. The president did not seek a mandate from his country. In fact, in a more mature parliamentary democracy, this debacle might have prompted a general election or at least the immediate resignation of the president and the cabinet. Of course, it didn't happen here. Nothing seemed to constrain the president as he took these decisions. Not a law, not the constitution, not his party, and certainly no institution of government. So he could just hire and fire as it pleased him. And this is nothing more or less than arbitrariness. So what about expropriation without compensation? In December 2017, as you all know, the African National Congress, which is an admittedly private organization, decided that expropriation without compensation would become a policy pillar of that party. Fair enough. But 2 months later, the assuredly not private organization, known as Parliament, adopted a resolution that effectively committed that institution to expropriation without compensation. And this resolution established the Parliamentary Constitutional Review Committee that would, over the course of 2018, determine whether the Constitution needs to be amended in order for expropriation without compensation to proceed. Of course, we know that they decided yes, that it should. The Land Panel as well recently decided that this is what needs to happen. So the arbitrariness of this whole exercise was almost immediately obvious. There was no real rational problem that a problem statement by government, by parliament, or even by the ANC as to what exactly the problem was that they want to fix. As the FMF's executive director, Leon Lowe, has pointed out repeatedly over the months since that happened, the land audits that government likes to point to have been not only been methodologically flawed, but also based on flawed premises. So the numbers they contained are virtually useless, without a reason to guide us to what these numbers mean, and mostly arbitrary. They measure nothing of substance. For instance, the numbers in the land audits include the barren wasteland of the Karoo and the Kalahari. I know some of you may have an affinity for these areas, but nonetheless you can't really farm them unless you have cattle or something, which are admittedly mostly private. So yes, these areas mostly contain privately owned land. But the land audits did not include, for instance, municipally owned land, and I think they classify that as private, which is bizarre, and which these are prime real estate. In Bryanston, in Johannesburg, for instance, there are open plots, and these open plots, the most expensive, the best real estate in the country, owned by government, it stands dilapidated. They also regard the vast tracts of land owned by our state universities, for instance, as private property. Totally absurd. And they assume that people with the surname Van Rooyen, for instance, on deeds registries were white, And as we know, that is not necessarily the case, but nonetheless, that's what government assumed in its land audits. But most importantly, neither the land audits nor any policy paper by government has adequately set out what it is government is trying to do. So when, for instance, will this land transformation actually be adequate, satisfactory? Now, as free marketeers and liberals, we would argue that land and property that was seized by the apartheid or the colonial regime and dished out to its cronies should, as a matter of course, be returned to the people who it was taken from or their descendants. This is known as restitution, and it's an imperative and indeed a core feature of our Roman Dutch common law tradition. So there's no controversy about that. But government treats restitution with contempt, giving only a fraction of the national budget in the process, and staffing the land claims court now, last time I checked, with only one full-time judge. There are a few part-time judges. But what government is obsessing over is redistribution, not restitution. Redistribution is the taking of land virtually at random, and in theory, handing that over to previously disadvantaged individuals. But in fact, what happens is government takes ownership of this property and leases it out to these previously disadvantaged individuals. And of course, we know that you have to own property to have the real incentive to develop it, etc. And if you know that government is going to take it back in 25 years or next month, then you're not really going to do anything with it. And reality has really borne that out for us. So when will land ownership be sufficiently transformed? Is it when all land is owned by the state? When all land is owned by black individuals? When white and black individuals own land that is directly proportionate to their population sizes? Do we include the barren Karoo and Kalahari? What about the vast tracts of fertile land on the eastern seaboard, which is mostly owned by the state? We don't know. So the point I'm trying to get at is that government has proposed a solution, expropriation without compensation, to a problem that we don't really know exists in the first place. The statements around EWC from government have been almost exclusively framed in restitutionary rhetoric. They talk about the original sin, land was taken, yes, land was indeed taken, and land must be given back. As free marketeers and liberals, we totally agree with that. But when government uses the restitutionary rhetoric, they are actually talking about redistribution, which is something totally different. And for instance, the ANC several months ago now published a list of 30 farms in the Northern Cape that it plans to target for expropriation without compensation. The reason it said that it wants to distribute the land to, quote, especially young people who are interested in working the land. It doesn't say these are the descendants of people whose land was taken, just says these are young people who want to work land, so we're going to give them land after expropriating the property. They say those farms have long-term occupiers. It's not a reason to take someone's property. They say there are adverse living conditions on the property. That's maybe something for the state to look into, but it's not reason to seize it without compensation. And there have been losses of shares. I mean, what does that even mean when it comes to expropriation of that property without compensation? None of this has anything to do with restitution, nor any discernible constitutional mandate that government has. So government has admitted as much during the public participation process by the Constitutional Review Committee. It said that the Constitution was not to blame for the slow pace of land reform, and government took the blame. It said, yes, we have failed. We've been slow. We are to blame. It's our fault. I think President Cyril Ramaphosa himself said repeatedly that, no, the Constitution's fine. It's us. We're not doing enough. And principally, they accepted the idea that the Constitution already somehow provides for expropriation without compensation, saying that if it is just and equitable not to provide any compensation, that would be constitutional in the current dispensation. I totally disagree with that argument, but they say that. So the point is that government has admitted that the Constitution does not really need to be amended because it can already do what it wants in terms of the Constitution. Yet we find ourselves with this proposed amendment. Why is a constitutional document being amended when the government thinks it's not necessary? This is arbitrary, and it amounts to nothing more than a power grab by the state. Now, there are many other examples. For instance, the tobacco bill wants to regulate vaping because it may be dangerous to health. You know, Massachusetts in the United States banned vaping, I think, 2 days ago. May be dangerous. Yeah, the hate speech bill, there's a lot to read about that. Metro police will arrest you for driving without a license. If you have waited weeks for their colleagues in the traffic department to issue your new license, that is not justice. But in any event, my thesis tonight is that the courts are allowing it. And they have allowed this bad behavior by our government when they are constitutionally and traditionally, really, regarded as the institution that needs to stop it. So some of you may recall that the issue of the president having to provide reasons for his hiring and firing of ministers went to the Constitutional Court very recently. Some people have lauded and others have lambasted that judgment. But the judgment, like so many others, was very technical and concerned an interpretation of the uniform rules of court. At no point in the main or in the secondary judgments was the rule of law, I think, even mentioned, even though this is a case that dealt with arbitrariness at its heart. It is also exceedingly likely that the courts, when they are inevitably called upon to set aside the amendment that will be made to the Constitution for expropriation without compensation, that the Constitutional Court will decline to do so. I am a cynic, that is a fact, but I can only see the Constitutional Court setting an amendment aside if it is enacted in a very procedurally improper manner, but not because the substance of the amendment offends the logic and the spirit of the Constitution and the rule of law, as it will. Now, there has been a lot of talk recently in the media about whether the courts are corrupt and whether criticisms of the judiciary should be entertained or even allowed. Now, since my talk tonight is largely a criticism of the courts, I must say up front that I do not wish for anything that I say to be seen as disrespectful. I have major respect for the court system, for the tradition that it exists in. I also don't think our courts are corrupt. I don't think our judges are criminals. But in any constitutional democracy, there must be allowance for fair and informed criticism of the courts. And South Africa, I think, has lagged behind with this. We laud our courts, we praise our courts, very uncritically, I must say, from my perspective. Whereas in the United States, there's a healthy discourse. It's fair game to discuss the quality of judges and of judgments, and there are various perspectives. You absolutely do not see that in South Africa. So the rule of law requires both a strong court system, but also a strong and independent civil society that is willing to speak up when the courts get it wrong. But before I get to the judgments I want to discuss today, let's briefly consider the discourse and rhetoric around the rule of law. As we have seen, the term is totally overused. I went into that, and it seems like everyone and their dog apparently thinks that the rule of law is just a good idea, doesn't mean anything really, it just sounds nice and it's great. But then perhaps ironically, the notion is criminally neglected and underutilized by the courts. And they are entrusted with safeguarding the rule of law, but they shy away from using it as an explicit legal device in their judgments. Instead, they go for rationality and legality, which are central aspects of the rule of law, but the rule of law is far broader than that, and other than rationality and legality, it is practically totally ignored. Of course, they use the rule of law as a nice sounding conclusion in their judgments, but rarely is this something of substance. There's also a very unfortunate dichotomy in South African discourse around the Constitution and the rule of law, and that is that people on the so-called right, I guess, argue that the Constitution is socialist. It has undermined property rights, the Constitution has undermined Afrikaans language rights, and therefore it's illegitimate. The other side, of course, the left, if you will, say that the Constitution was a compromise and it basically just entrenched structures of privilege and is therefore illegitimate and should be set aside. So there's this unfortunate dichotomy that I, in the book, try to bring clarity to. I talk a bit about the Constitution and about the rule of law and what they mean in substance. I tried and hopefully succeeded to cut through the rhetoric and platitudes. And in so doing, I spent a lot of time focusing on how the rule of law as a concept is co-equal with the Constitution as per its own declaration. We'll get to what the Constitution says specifically, but the rule of law is not subordinate to the Constitution, as our courts have implied that it is. And so the major focus of the book is on the rule of law, but I also speak a lot about the Constitution and specific provisions in the Constitution, which I regard as very relevant to the rule of law in the abstract. So what does the Constitution actually say? Section 1 is part of the founding provisions, and Section 1 is the most entrenched provision in the Constitution. It requires 75% as opposed to 2/3 of the National Assembly to amend it, and I believe still now, and even during apartheid, the governing party or its coalition friends has never had 75%. So it's a very entrenched provision. And this fact alone means that the rule of law is not simply filler, poetic stuff in the founding provisions that cannot be used. It means it's an important part of the Constitution. But please note the and. Supremacy of the Constitution and the rule of law. And that is what people very often, jurists, judges, very often ignore. And obviously you can see where the name of the book came from. The Constitution and the rule of law. So briefly, what is the rule of law? So with this long haul story in mind, most legal academics have battled over a very precise definition of this term. Most people know academics, judges, and have an idea of how to describe the rule of law, what its features are. They have a gut feeling for what the rule of law is about, but it's very difficult to get to a definition. And what people often say is that the rule of law is the opposite of the rule of man. It is a government of law and not of personalities. Now, what this tells us pretty much nothing, but on deeper analysis, you might deduce what the rule of law means. If it is said that it is the law that rules, and not the personality of man, it implies that emotions, feelings, and transient political passions do not and should not govern society. Instead, society must be governed by relatively fixed rules that are knowable and known, accessible, certain, and reasonable. Without defining it then, I always describe the rule of law as that legal institution that averts arbitrariness. It is an aversion to arbitrariness in a legal sense. And one of the results of having the rule of law, of having society governed by fixed, knowable, accessible, certain, and reasonable law, is that oppression becomes improbable, if not impossible. In this regard, as the chairman of the Affirmative Rule of Law Board, Rex, defines it as that the rule of law is a barrier that the law sets against tyranny. And I think that's also a very apt way to how to consider it. But we must also consider what the rule of law is not. And this is, I think, a very important thing. A lot of this is where people like Herman Mashaba, Cyril Ramaphosa do get it wrong. The rule of law is not law and order. Law and order is a social phenomenon where the people, which describes whether the people in society obey the law and the law is enforced by the police. Very much a grassroots type of how the law is seen and enforced and adhered to. But the rule of law itself does not care. Does not care whether ordinary people adhere to laws, but instead is totally concerned with the conduct and affairs of the three branches of government. The rule of law is a public law, not a private law concept. Secondly, the rule of law is not law enforcement. Just because the police prefer to sit under a tree and eat fish and chips rather than do their jobs does not mean there is a lack of the rule of law in South Africa. There is absolutely an overlap here, especially insofar as equal treatment under the law is concerned. But this is a matter of incompetence, and that does undermine the rule of law, but it is not itself what the rule of law is about. Lastly, many South Africans think that the rule of law is absent because parliament and government does not enforce our good. Apparently we have good laws, there's just bad enforcement. I think we have terrible laws, and I'm so glad that they don't get enforced. And there are implications for the rule of law if the laws are just passed and the people adhere to them only for government not to care. But again, this is not what the rule of law means. In fact, as I said, the rule of law in many circumstances is probably better served if government rather does nothing, including failing to enforce its laws, its terrible oppressive laws. Now with that, that's all I'm going to say about the rule of law in the abstract. If you want more on this, please read the book or watch the talk I did earlier this year on YouTube. But now I want to turn to the judicial contempt for liberty. But I must make one extra disclaimer. I know there are some eminent legal minds in the audience with a nose for bullshit. So I am going to simplify a lot of the details in these cases because of time constraints and because I don't want to bore you to death. And I also only discuss the aspects of those cases that I think are relevant to tonight's topic. But feel free to correct me afterwards if you feel I made a mistake. But do please bear with me as I try to make these cases digestible for this event. So, Agri South Africa versus Minister for Minerals and Energy. It's probably the case I have spent most of my research and etc. into the case I thought about the most, and probably one of the worst cases that came out of our constitutional court in the last few decades. So that's the case I will focus on tonight, but not the only case. And I think everyone who has a passing interest in property rights in South Africa has an inkling about what happened here. So basically in the early 2000s, the Minerals and Petroleum Resources Development Act, MPRDA, came into being. It declared that the mineral wealth beneath South Africa is the common heritage, common property, whatever, of the people, of everyone. Just to note that in South African private law, there is no such legal person known as the people. It doesn't exist. And it said that the MPRDA said that the state will be the so-called custodian of these minerals. Now this had the undeniable and I dare say indisputable consequence that all privately owned minerals in this country were expropriated without compensation, and the state became the owner of those minerals, in effect, if not in law, or apparently not in law. So Sebenza, represented by Agri SA, challenged this and said they were entitled to compensation because the Constitution did, and that still does, require a compensation when expropriation takes place. Now, there is virtually unanimous opinion amongst legal academics, especially people like Pieter Badenhorst and Johan van der Vyver, eminent legal minds on mineral law, that there was an expropriation and that the state became the owner. The High Court agreed with them, and the two minority judgments in the Constitutional Court also agreed with them. But since the Constitutional Court, in all its wisdom, was unwilling to let the commonsensical and properly constitutional position win out, it decided that to be a contrarian, as it very often does, and very unfortunately. So the majority of the court, per the opinion of Chief Justice Mogoeng, made a truly bizarre judgment. As if the court was acting as the public relations office of the Minerals Department, the court said Parliament had done a great job to try and bring about transformation in South Africa. It used the word painstaking to describe just how much effort Parliament had put into the MPRDA. Now, I must be honest, as I read the judgment, this is the face that came into my mind, Donald Trump talking about how brilliant the legislation and his work is. But I think this was very inappropriate for a superior court of law to engage in this type of rhetoric. I mean, it's a great party, it's just great. But the essence of the judgment was that the court found that the state did not acquire ownership of the minerals. And because it did not acquire ownership, there was no compensation necessary because, according to the court, for expropriation to take place, the state must become the owner. If the state does not become the owner, there's no expropriation. The court said, and I quote, there was mere deprivation, and that is section 525. So the Constitution apparently makes this distinction between deprivation and expropriation. I have thoughts about that, but let's get into substance over form here, because that's it's ridiculous. The court also said something else very, very interesting. The court said, we are apparently under a constitutional obligation not to overemphasize private property rights. I know section 25 of the Constitution pretty well. I've never read this in my life in that section. We must see property rights against the background of the ostensible imperative for transformation, the constitutional imperative. And because the MPRDA was intended to give effect to transformation, government's policy, it represents a justifiable limitation on property rights. That's what the court says. Now, the major issue that I focused on in this case was the Constitutional Court's preference for form over substance. And this is where the rule of law aspect really comes in. Now, I don't want to bore you with substance over form, a very technical legal thing, but I hope I'll make it quite understandable for you. So South African law, like most legal systems around the world, subscribes to substance over form doctrine. And this is also well known in accounting. It speaks for itself. The substance of something must be given more weighted preference than its form. Substance is the reality of it, the fact of it, the thing that you can see, the thing that you can touch. The form is the facade, the pretense of it. So substance over form. Now, in the seminal case of Harris versus Minister of the Interior, from the 1950s actually, even our pre-constitutional Supreme Court had the following to say. Courts must look, quote, at the substance and not merely the form of the act. Were this court only to look at the form of legislation, constitutional guarantees might be of very little value, close quote. So let me try and simplify substance over form. You are a judge, imagine you are a judge in the Supreme Court of Troy. This is after the sacking of the city by the Greek armies. Now, in this case, the people of Troy allege that the Greeks engaged in fraud. They hid soldiers in that horse, in that wooden horse that they left outside the city gates. But the Greeks say no. The Trojan horse was a genuine gift from the gods, and we had no hand in that. That wasn't us. It's a gift from the gods. Why is this even in court? So what do you as a judge do? Do you look at the form of the matter? In other words, this is a wooden horse representing a spiritual symbol of the Greek religion? Or do you look at the substance of the matter and say, this is nonsense. This horse was just a thing for soldiers to ride into the city on and wreak havoc. What do you do? Whatever you decide, the fact is that the rule of law standard demands substance and not form. If form were the standard, legal protections against invasions of our rights would be of very little value, because government can simply say in its own legislation and regulations, this may look like we're violating your rights, but actually we deem it that we're not violating your rights, so therefore you can't challenge it in court. That's ridiculous. So what did the Constitutional Court do in Agri SA? Engage in circular form over substance reasoning. It said that the MPRDA's assigning of mineral property to the state cannot be arbitrary. Now remember, the Constitution prohibits both arbitrary deprivation and arbitrary expropriation. But the court said it cannot be arbitrary because the objectives and the transitional provisions of the Act say that it is not arbitrary. It has a noble reason, therefore it cannot possibly be arbitrary. So if government wants to bring back the death penalty, for instance, all it needs to do is say in the legislation, quote, the death penalty does not infringe on the right to life. And the Constitutional Court will say this is fine. That is absurd. It is totally absurd. So the court paid far more mind to the intentions of the legislation rather than what the legislation was in fact doing. Now, as I said, legal academics, the High Court, and the minority judgments agreed that in substance the state had become the owner, in substance the state had expropriated the property. And it doesn't matter that the legislation, the text says custodianship or whatever, the state had become the owner. But the majority of the court did not want to accept this. To them, because the legislation said the state was merely the custodian, it cannot be the owner. It's total formalism over substance. But the court did something else that is also absurd. I don't really know what the court was doing in this judgment. It was straining itself to find that minerals were not expropriated, as if the court believed that expropriation were a constitutional evil. Now, I am a libertarian. I think expropriation is as evil gets. But the court is not libertarian. The court is the Constitutional Court, and the Constitution says that expropriation is a perfectly legitimate tool that government may use in pursuing its objectives. It's fine. We have expropriation in this country. I don't like it, but we have it. But the court was so intent on concluding very illogically that there was no expropriation. Why? Now, I have my own view on why this is, and it's the cost implication. The ANC later estimated that it would cost upwards of 1 trillion rand to compensate all private mineral owners for this expropriation. The court, I think, knew that the state could not afford to pay and made that the real reason for its judgment rather than this custodianship twaddle. So it hid its real reason for this finding under nonsense that really nobody agrees with other than that bench. Now, the result of this judgment, even though the court said it was not setting a general principle, is that in theory government can now expropriate anything simply say it becomes the custodian and not the owner. Advocate Tim Wim Trengrove even told Parliament during the oral presentations on expropriation without compensation that government should do this rather than amend the Constitution. So the authoritarians in our society are aware of what's happening here. They know the Constitutional Court is willing to sanction expropriation without compensation already, even without an amendment. And this is very worrying indeed. Now, I want to conclude with, on this case, with how ideological the Constitutional Court was in this judgment. It still sits with me how bizarre this really was. And here's the quote from the majority. The MPRDA constitutes a break through the barriers of exclusivity to equal opportunity and to the commanding heights of wealth generation, economic development, and power. It addresses the injustices of the past in the economic sector of our country in a more balanced way by treating individual property rights with the care, fairness, and sensitivity they deserve. Seriously, it's as if the minister himself, the Minister of Minerals, wrote this judgment. It's bizarre. So in so saying, the court assumed the efficiency of the legislation. It assumed the legislation was actually doing what it said it wanted to do. Now, it's a principle of our law that courts may not inquire into the efficiency of legislation because it's a policy and a political matter. But the court made just how good the MPRDA was a really integral part of the judgment. And I think we all know what this term commanding heights refers to. It's our friend Vladimir Lenin's phrase when he described how revolutionaries must take the commanding heights of the economy from the evil capitalists. That our highest court is engaging in this kind of talk must frankly shock all constitutionalists. Even if you are yourself a socialist, the court is not an instrument of your ideology, or it ought not be. So the court totally ignored the founding values, like the rule of law. Had they considered the imperatives of the rule of law, like reasonableness and substance over form, they should ideally have found the MPRDA totally unconstitutional. But as a second best, the court should have concluded that expropriation did take place and that the people who had their property expropriated must be compensated. Next case, Reserve Bank versus Shuttleworth. The Currency and Exchanges Act of 1933, very old, gave the Governor General, now the President, the power to suspend or declare invalid legislation that conflicts with his regulations in terms of the Act. All that was required was for his regulation to deal with any matter directly or indirectly relating to currency, banking, and exchange. So basically, the President, as an executive functionary, can, by executive fiat, set aside parliamentary legislation if they conflict with his legislation. So I'm not going to run through the facts here, but basically the Reserve Bank levied an exit charge on Mark Shuttleworth's capital, and he went to court about that. But that's not the point here. So this is what the majority, per the Deputy Chief Justice de Kamotsenek, has said in the matter between the Reserve Bank and Shuttleworth. The provision giving the President or their delegate this power was constitutionally valid, apparently, because the complexities involved in currency, exchange, and banking are so monumentous that the government needs flexibility to respond to these situations. So because it's convenient, government can do what it wants, basically. This is relatively a brief part of the judgment, since the court, again, was far more concerned with a technical question, which is whether an exit charge qualifies as a tax. So the lawyers in the audience obviously will understand why this is deeply problematic. You cannot have a situation where an executive functionary, a bureaucrat, an official, the President, has the power to make regulations that supersede those made by an elected assembly. It makes a mockery of democracy. And the Act's language is very broadly framed. Any matter indirectly or directly relating to currency, banking, and exchange, it's virtually an absolute power to make law on anything, because everything relates in some indirect way to currency, at least. So one can argue that basically any law that has, for instance, the levying of fines, which is many of our pieces of legislation, as a possibility, relates to currency, and as such can just be set aside by the President. That's totally unacceptable. It has often been said in the past by luminaries like Albert Van Dicey and Friedrich August von Hayek that the procedural adherence to the rule of law standard would protect liberty. Thus, it is not a necessary requirement to enumerate rights in Bills of Rights, but the rule of law itself, as some say, a procedural institution, would guard against tyranny. And this is why the British model of parliamentary sovereignty is still defended today as a valid means of attaining liberty. But in our case, the courts have shunned this idea. In the Shuttleworth case, the conclusion the Constitutional Court should have reached was patently obvious to most people trained in law, and the administrative law luminary Cora Hoekster agrees with this. She wrote very recent, soon after the case, that this is bizarre that the Constitutional Court would uphold something she called the Henry VIII Clause, this absolute power to just do whatever the President wants. The court would uphold that. It's absurd. The court had to declare the provision in the Currency and Exchanges Act unconstitutional, not only because the Act assigned a delegated lawmaking power to the President, but in fact assigned plenary lawmaking power, democratic lawmaking power to the President, to simply set aside acts of Parliament by executive fiat. So to add insult to injury, this Act is still part and parcel of our law, and the President, through the Finance Minister, still has the exact same power that the Governor General had in 1933. To me, it is amazing that President Zuma did not take advantage of this. If he had creative legal minds around him, he could have, I believe, set aside a lot of anti-corruption legislation to just save himself from jeopardy, because it somehow relates to currency, because he's stealing currency. So just set it aside. So it's very interesting that he didn't know about this. So by upholding this law, the Constitutional Court might just have given its stamp of approval, literally, to dictatorship by the executive government. But I'm glad that our politicians aren't keen and smart enough to realize. Next case. Minister of Finance versus Van Heerden. I don't discuss this case explicitly in the book, but I do discuss affirmative action, which is what this case is fundamentally about. So basically, non-racialism is also a founding value of our Constitution. It's Section 1B. It says that South Africa is founded upon non-racialism and non-sexism. So to give effect to this, Section 9.1 of the Constitution guarantees equality before the law, something we're all very familiar with. Section 9.2 says that government may take measures to promote the equal attainment of all rights and freedoms in the Bill of Rights, especially for disadvantaged groups. Fair enough, that's perfectly constitutional. Section 9.3 prohibits unfair discrimination that is based on a series of grounds, including race. Finally, Section 9.5 of the Constitution says that any discrimination that is based on one of these grounds is presumed to be unfair. And you have to prove, if you are discriminating on one of these grounds, that it's actually fair. Fair enough. So the question that the court had to answer was whether so-called restitutionary measures, in other words, affirmative action, amounts to unfair discrimination. Because, of course, it discriminates on a prohibited factor like race. Does the state, as the respondent in cases like this, bear the onus to prove fairness? Now, the court, again, per Moseneke, said that remedial measures are covered by Section 9.2 of the Constitution, and that the presumption of unfairness in Section 9.5 simply does not apply. So because Section 9.2 gives government this power, you can just forget about the rest of this very inconvenient provision of the Constitution. To the court, the Constitution does not envision government having to prove the fairness of affirmative action, because the Constitution already ostensibly requires such racial measures in the first place. So in other words, ordinary cases of discrimination must be treated according to a far heavier standard of scrutiny than cases of discrimination involving the state. That is absurd. To the court, the state can kick up its legs and relax when it's accused of discrimination. But if you, as an ordinary South African, get accused of discrimination, you have to go to court and make a very strong case for why you haven't committed unfair discrimination. That's absurd that the Constitution makes it easy for government but hard for the rest of us. What is that? It's nonsense. So I don't really have to go into much detail about this, because the court simply subverted the Constitution. It said, and I quote, it cannot, quote, cannot accept that our Constitution at once authorizes measures aimed at redress of past inequality and a disadvantage, but also labels them as presumptively unfair. But it doesn't matter whether the court accepts this or not. It's right there. That's what the Constitution says. It says, if you discriminate based on any of these grounds, it is presumed to be unfair, and you must prove it is fair. That is the text. It's there. Of course, government does have the power to engage in affirmative action. That's Section 9.2, but it cannot be racial. And if it is racial, it needs to say why it is fairly engaging in racial discrimination. That's what the law requires. So what the court did was replace what the Constitution very clearly and textually requires with its own view of how things ought to be. And this is one of the clear cases where the court's ideological commitment to government's racial affirmative action program was manifested. That is not good. The court ignored the founding value of non-racialism entirely. The literal founding value of our constitutional order was ignored when the case dealt fundamentally with race as a matter of public policy. The Constitution proscribes racial discrimination by the state, absolutely. I will stand by what I'm saying right here. It does allow affirmative action. We cannot get away from that, no matter how classically liberal we are. But it cannot be based on race or sex. Race and sex are founding values of the Constitution as things that the Constitution is trying to eliminate as a relevant element of public policy. South Africa is founded on non-racialism and non-sexism. Court ignored this completely. So, let's get to this very recent case, the flag case. Hopefully I can get through it with well, I can't. But yes, I will. The slides will be available. So the last case I want to discuss is the controversial flag case decided between the Nelson Mandela Foundation and Afriforum. So the relevant facts of the case are that Section 16.1 of the Constitution protects freedom of expression. Section 16.2 allows government to limit expression in cases of advocacy of war, incitement of imminent violence, and in cases of hate speech. But the Constitution very usefully defines hate speech for us. Hate speech is the, quote, advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. There is a constitutional definition of hate speech. The Equality Act of 2000, however, goes further than this and prohibits expression that is merely hurtful on additional grounds like culture, etc. The Act, which has not yet been challenged on the basis of its constitutionality, I think is very evidently unconstitutional. And I think many non-classical, liberal, very moderate legal scholars agree, in that it prohibits more speech than what the Constitution allows government to prohibit. So as we know, in this case, the Equality Court was asked whether the display of the old South African flag amounts to hate speech. Now, of course, I need to disclaim, as we continuously have to do, that yes, the flag represented a great evil. I've talked about how this government violates the rule of law. The government before 1994 did it just far worse than what our current government does. So yes, it was a time of tyranny. That flag absolutely, I think, represents that. It's bad. Don't fly the flag. Bad idea. Can also get you in jail now. So yes, it's not a good idea, but it's morally not a good idea. I think legally there should have been a different conclusion. So very briefly, the court, as per Deputy Judge President Mojapelo, said that any display of the old flag that is not for artistic, journalistic, or academic purposes is gratuitous display. Now, the word gratuitous means that it is for no good or justifiable reason. But neither the Constitution nor the Equality Act uses this word. It does not say anywhere that if you do it for any reason other than the mentioned artistic, journalistic, or academic purposes, it's for no good reason. That's not in the law. That's something that the court unfortunately just made up. So to the court, when the old flag is displayed gratuitously, the only reasonable and so-called objective intention, odd as that may sound, is that the person displaying the flag wishes to be hurtful toward black people and that they are defending the crime of humanity known as apartheid. Now, I probably agree they are assholes, to put it bluntly, but to draw these inferences is probably not necessarily the case. But the court then said, because it is hurtful, it amounts to hate speech. So there are many problems with this judgment, but given the time limitations, I just want to mention two. The first is that the court put the cart before the horse. And second is that the court was too impassioned about the dispute before it and not sufficiently disinterested. So just on the second point, so the respondent in the case was Afriforum. We know, very seemingly white conservative organization. But then also an amicus curiae was the Federation of Afrikaans Cultural Societies, the FAK. Now, when the court criticized the submissions by the FAK, at one point the court says, even Afriforum says that the flag was offensive. How dare you not agree with them? Even Afriforum. Now, I must say that is, you don't want a court saying, even that guy, even one of the parties believes this. You don't want the court to say that. It means the court has inserted itself into the situation. It's getting very impassioned about what's going on. And I mean, you can't guard against that absolutely, but a judge is trained. He needs to be able to excise himself from what is happening in the case before him. Now, on the first point about putting the cart before the horse, the court spent a substantial part of the judgment on the history of the flag, and that is fair enough. But we must bear in mind that judges are not trained historians. History is a discipline with its own rules, its own assumptions, principles that you do not get taught in law school. I'm a lawyer, I know. But during the analysis of the history, the court somehow already found the old flag guilty of hate speech. It went through the history of its adoption, how it was flown during the apartheid era, and how during that time it represented the fusion of the two white races, the English and the Afrikaners. And during that discussion, the court came to the conclusion that this flag is basically just no good. You can have no good reason for displaying it. Essentially, before the court even looks at what the Constitution says, what the Equality Act says, what the common law says, its conclusion was already reached. Now, very bizarrely, and I'm not quite sure this is appropriate, but the court applied a trademark law test to determine whether the so-called dominant meaning of the flag, the trademark, so the history of the flag, is offensive to most black people. And surely it is. But the question remains why the court went to trademark law in a constitutional issue. The Constitution gives us the test to determine hate speech. It's right there. We don't need to go to trademark law. So in other words, the court did very many things in this judgment, but none of them included actually looking at what the Constitution says. And this is what the court had to do. It had to consider firstly whether there was advocacy. There must be this call to action. There must be an advocate of his position when you fly the flag. It had to consider whether that advocacy amounted to hatred as opposed to something else. Condescension is not hatred. Dislike is not hatred. Hatred is a very intense emotional disposition. Had to determine whether the advocacy amounted to hatred. It had to consider whether that hateful advocacy was based on race, ethnicity, gender, or religion. Those 4 grounds, nothing more. And finally, and most importantly, I would argue, and this is something that is very often ignored, it had to consider whether that hateful advocacy also amounts firstly to incitement, a call to action. The flag gets people going, they're going to do something now after seeing this flag, incitement. And secondly, that incitement must amount to incitement to cause harm, as opposed to causing something else, like offense, like emotional, I don't know, but I know our courts have started to move in the direction of considering emotional damage to be harm. I think that is very dangerous. Lots of things offend all of us every day. That should not be a ground to go to court. Offend us deeply, I must add. But most importantly, I think, is that the court tried to establish a general principle. It did away with case-by-case basis, which is what a court fundamentally is. It needs to decide disputes before it on the facts. The constitutional test that I just outlined, advocacy of hatred based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm, that is a test that can logically only be applied to the facts before the court. It cannot be generalized. Cannot say that the flag generally advocates hatred and that there is a general incitement, and in general it will be incitement to cause harm. But that is what the court did. It said that any non-artistic, non-journalistic, and non-academic display of the flag by its nature constitutes hate speech. And I think this is very improper adjudication. The court should not have done this to say that as a general principle, this is now hate speech in every single case. And of course, hurtfulness is not recognized as a ground by the Constitution. To limit freedom of expression, the Constitution is clear. And there must be incitement to cause harm. And unfortunately, the court ignored that. So let me conclude by trying to answer the question of what went wrong with our courts. After apartheid period of insane oppression of the majority of this country's people, we were hoping that this constitutional state will bring us courts that protect rights, that are impartial, that don't let the transient political passions of the current ruling elite become its lodestar in the way it adjudicates cases. So let me venture what I think the answer is. Now, because the rule of law is a founding provision, it permeates the Constitution itself. Everything in our founding provisions must be borne in mind when the Constitution is read, when legislation is read, when government conduct is considered. Now, in the book, I give extensive attention to cases in the Constitutional Court where this has not been done, and this is what I covered tonight. Our highest court has unfortunately read its own ideas into the Constitution, and it has used the mantle of so-called transformative constitutionalism. Now, transformative constitutionalism has nothing to do with the Constitution, and it has nothing to do with the rule of law. and is far more concerned with the ideological preferences of the political class. Like libertarianism is an ideology, like classical liberalism is an ideology, transformative constitutionalism is an ideology. And we need to be careful about using this word constitutionalism in conjunction with transformative. And that's why I think Professor Koos Malan should probably be followed in just calling this transformationism as an ideology. And this can really be considered as the jurisprudential dimension of the so-called national democratic revolution. And this is not something I'm just saying, this is something you'll see academics of that mind saying the same thing. We need to implement the national democratic revolution. The Constitutional Court has done this very well recently. So this is not just me with a conspiracy theory, this is something very readily admitted to. Now, transformative constitutionalism specifically was introduced into South African law in 1998 by an American chap called Karl Clare. Now, what he tried to do was guilt trip the judiciary of the time into adopting a so-called progressive stance on constitutional interpretation. If the courts did not do so, Clare argued, future generations will look back and point to the courts as the reason why South Africa failed to transform. Now, I think we can see that with the economy totally collapsing in somewhat part due to the government's intensive regulation of the economy, with the state's stamp of the court's stamp of approval, especially in mining, which has almost entirely collapsed as a result of zero property rights. We can see that future generations won't be looking back and saying, why did you not implement transformative constitutionalism? The question will be, why did you set aside constitutionalism for this ideology that has totally destroyed the economy and will continue to do so? What all of this means is that the Constitution that you and I can download from the internet right now and read is not the same thing that the courts work with on a daily basis. You and I might read in Section 18 of the Constitution that says, quote, everyone has the right of freedom of association. It ends there, there's no exception, no proviso, it doesn't say except when limited in terms of law, blah, blah, blah. It just says everyone has the right to freedom of expression, freedom of association. But in effect, it is supposed to be one of the strongest rights in the Bill of Rights, because during apartheid there was no freedom of association and the Constitution tried to put that to an end. But you will find that in reality, Section 18 doesn't exist really. It's rarely mentioned in constitutional cases. And if you, for example, dare create a space where only Indian South Africans are allowed, or a single men's night at a bar, you and your customers will have no freedom of association. The courts will come down hard on you for even considering doing something like that. If you are one of the 10 million unemployed in our country, and you wish to associate with an employer who offers you less than a minimum wage, but gives you other benefits like housing, healthcare, etc., again, the courts will say, no, you have no freedom of association here. You have to be paid the minimum wage. Basically, the National Minimum Wage Act is now more important than Section 18 of the Constitution. That's in effect what the case will be. You will not find refuge with the courts on grounds of freedom of association. But there are many others like this, freedom of expression, the right to privacy. There's even a right to freedom of security of the person, which says that everyone has the right to freedom in South Africa, for instance. You have the right to be free from all forms of violence, private and public. Now, if I go to the court and say, I'm being taxed, I said, no, I don't want to pay tax. The government is coming after me, it's coercing me. The court is going to laugh me out. Yet there it is in the Constitution. I have the right to be free from all forms of coercion, public and private. It's ignored. So I'm not saying that taxation needs to be declared unconstitutional. I'm saying that the courts don't even interrogate the issue, and that is the problem. Now, yes, there are many other provisions where the Constitution has been read in an ideological way, where the court uses clever sophistry to justify it, but in effect, they put things in the Constitution that are not there, and they remove things which are there. Importantly, the rule of law. Basically, Section 1C does not exist to our courts, not in any real substantive sense. So the courts interpret the Constitution through this prism of transformative constitutionalism, and as a result, the Constitution is employed to pursue so-called social justice, egalitarianism, and progressivism. None of these words appear in the Constitution. Social justice appears in the preamble, but the preamble is not a provision of the Constitution. There are provisions in the Constitution, however, which say that government must pursue freedom, equality, and human dignity, and an open and democratic society. All of this is simply ignored by the courts, basically. And if they do talk about it, it's only in the context of why it doesn't really apply. But what is key to understand is that it is the courts, not the Constitution, that has led to these things happening. We often blame the Constitution, forgetting that it is in fact an inanimate charter. We would do well to look at America for inspiration. For over 200 years, the courts there have been controlled by competing political factions. This has resulted in very different interpretations of the US Constitution at very different times. But through it all, most Americans remain dedicated to the Constitution, regardless of their race. And they have continuously engaged, and I include ordinary Americans in this to engage in a dialogue about what the Constitution means to them, what it means in law. Maybe they haven't done so with intellect, but they've engaged in the discussion. We in South Africa, we don't. We defer to the Constitutional Court, and whatever it says, we say, great, that's it now. And then if the Constitutional Court comes to a conclusion that we do not agree with, we conclude that it's the Constitution itself that now must be abandoned, and now that we must secede from South Africa and what else have you. I don't think that is a strong liberal position to take. I think as liberals, we own constitutionalism as a concept, and I think we need to own the Constitution as a liberal end that was put to apartheid, and something that we should defend, even though the courts are not in our corner. We need to keep the discourse alive. So we need to regard the Constitution as a weapon in the arsenal of liberty and not an obstruction. And of course, we need to give effect to everything in the Constitution, including the very idea of constitutionalism, which includes the rule of law and its litany of measures that can be used to combat arbitrariness, to defend liberty. So in the conclusion of the book, I make a plea for South Africans to stop with the obsession over personalities. We keep hearing that all that Eskom needs are competent people. We keep hearing that we need to get rid of corrupt individuals and all will be well. Around election time, we keep debating whether Cyril Ramaphosa, Nkosazana Dlamini Zuma, Julius Malema, Musi Maimane, or Pieter Groenewald are the best person for president. We also keep hearing that the current bench of the Constitutional Court will never see the Constitution as a charter of liberty, but rather one of social engineering. Now, in my view, we're missing the point if we keep harping on about personality. Eskom does not need competent people. Eskom, for once in its centuries-old lifetime, needs to bathe in market forces. It will then either crumble or it will employ competent people. We don't need the government to employ competent people. The company itself will do so if it truly faces extinction. It doesn't need a new board or CEO, it just needs competition. Institutions, not personality. Getting rid of corrupt individuals won't do any good. The Zondo Commission is a great debacle to behold, it's a nice drama, but the Commission is not investigating the legislation and the laws that have allowed these officials and politicians to be corrupt. Usually when there's corruption, you can trace that back to a provision in a law that says the registrar or the minister may do so if he deems it in the public interest. That is where corruption comes from. The Zondo Commission isn't looking at that. So when this lot of corrupt individuals are jailed, the personalities go away, the next lot will come, they'll have the exact same powers, we'll do it all again. And it shouldn't matter who the president is. The fact of the matter is that the president has too much power. And this is what we should, this is why we are worried about who occupies the office. At a very, base level, we understand something is wrong, and that is why we are very keen on getting our guy to be president, whereas in Switzerland, for example, nobody cares, because the president of the Executive Council is a position that's rotated. The Executive Council itself has no power. Nobody cares who takes that position because they can't really do anything. That is what we need to see in South Africa. So we can consider the problem is systemic and structural, not personal. So we can constrain the powers of the president significantly if the rule of law standard, as found in Section 1C of the Constitution, is adhered to. And if we interpret the Constitution in line with this, for instance, with the appointment of ministers, we say, no, you cannot just appoint anyone. You must give reasons for why person X is qualified for this job, and you must explain why the 500 billion rand we're losing in the economy is worth it for this one new person. You need to explain that to us. Don't just arbitrarily pick and choose new people. Tell us what is going on. So the source of the problem can only be fixed once we regard institutions as more important than personalities. The rule of law is one such institution that has not enjoyed our sincere attention or effort, and we suffer for it. Only once we start placing institutions like the rule of law, property rights, etc., front and center in our political and legal demands, rather than nonsensical things like good personal ethics and whatever, welfare, then we'll become a prosperous and free democratic society. Now the book is available there in the back at 150 Rand per copy. If you stick around, I will sign it for you if you wish. Those of you who do buy the book, please be as critical as you need to be. I am not saying that my word is final. I want everyone who disagrees with me to tell me why, and maybe you'll find your way into the second edition that I'm already working on. So I would really want your criticism and commentary, as long as it's constructive and not ad hominem, etc. So you can come by and talk to me after this, or you can email me. My email would have been on this screen. But yes, you can very easily find in my information on the Rule of Law Project's website. That is www.ruleoflaw.org.za. You can find me there. And you can also visit the Free Market Foundation's website, www.freemarketfoundation.com, and you can contact us and then just ask for me, and I'm more than accessible. Alternatively, I'm always on Facebook. You can always contact me there. So yes, I would greatly appreciate your commentary on the book, on this talk. And I thank you for your time. I hope I haven't kept you all too long. Thank you. Any questions?
Two quick things. Firstly, do you think there's any problem with the formulation of the rule of law in Section 1C as interpreted by, say, cases such as the Transfer to International Council and various other cases? And based on that, why do you think there's a dearth of litigation based on Section 1C if the rule of law is such a helpful tool against arbitrary executive policy?
Well, so on that second point, I think advocates in this country are quite conservative. It doesn't matter whether they're free marketeers or socialists, legally they are extremely conservative. They do not come up with new things, new ways to challenge government. Generally, they look at precedent. And in our precedent, there is very little that says that the rule of law is a concept that you can rely on directly to challenge government. And I think that's to your first point, how the courts have already dealt with the rule of law is totally inadequate, because it has basically been said that the founding provisions are not, you cannot rely on them directly. You have to go to the Bill of Rights. That's a problem. That's a big problem, because you cannot, I don't think the Constitution itself tells the court, the judiciary, that we're just putting this here to guide people. You cannot really rely on it. If you can rely on any other provision of the Constitution, which says the president must do X, and say that the president did not do X, there is no real reason why you can't say that the president, by doing X, has contravened an imperative of the rule of law. In America, for example, and even in India, there's something called the Basic Structure Doctrine. It says that there are certain values that permeate our Constitution. And you can come to court and say that what government has done here violates liberal democracy. And the court will say, well, yes, that is a principle that underlies our Constitution, and we'll look at what you're saying. That is how the rule of law should also be seen in South Africa, but our legal profession isn't there yet. We don't feel comfortable going out on a limb and saying, actually, Chief Justice Mogoeng, we're going to rely directly on Section 1C now. We know we're probably going to lose with this bench, but maybe the next group is a bit more open to taking that. Any other questions? Come on, people, come at me.
Do you have any principles that underline or describe arbitrariness?
So the way I think it is ordinarily described is that it's the opposite of reasonableness. And reasonableness, I think, is understood in law to mean that whatever is done needs to be rational. In other words, it needs to be connected with a legitimate government purpose. It needs to be something in the Constitution. Government isn't just doing something because it wants to. It actually says, we're going to implement the right to healthcare, so we're doing this. Rationality. And then the second thing is proportionality. What it's doing needs to be aimed at actually achieving that and no more. So for example, expropriation without compensation. If government says there's been a slow pace of restitution, fair enough, that's a constitutional objective. But to now say we're going to amend the Constitution to allow government to just take property without paying compensation, that's disproportionate. And I think the third thing that is recently coming into reasonableness is effectiveness. So can what the government is proposing to do actually achieve what it wants to do? And if not, then it's not reasonable. So reasonableness, I think, is the opposite of arbitrariness. So if it's an aversion to arbitrariness, the rule of law being an aversion to arbitrariness, it means it's a demand for reasonableness from government. So that's the way I understand it.
Mark, you talk about that arbitrariness principle, but surely the rule of law rests more on a principle of completely disallowing any initiation of force.
So I'm somewhat of a radical libertarian. I want to agree with you, but as a jurist, I can't, because the rule of law as a concept, and I know people disagree with me on this, really came about in the context of the state existing. So in private affairs, I would argue there isn't really a need to not be arbitrary. If I want to draw up an arbitrary contract and you arbitrarily agree to it, then that's our lot. We're gonna suffer for it, but that's our choice. But the rule of law came about really in the context of the state existing. And as we know, the state, to do anything, needs to coerce. So I cannot imagine that by its very nature, the rule of law proscribes any coercion whatsoever, because then it really undermines its own foundation for existence. So for me, the rule of law is a response to the existence of legislation, the existence of government conduct, and it is a way to limit and circumscribe what government does in a way that is compatible with the very underlying nature of law. So for example, if government makes a law and it wants you to adhere to it, you need to know about it, obviously. You need to understand it. You need to be able to read it. And that law cannot just tell bureaucrats that whatever the law says, you have a discretion to just on the side do whatever you want anyway, because again, you cannot as a citizen change your behavior to match that. So the rule of law for me is a very state-based thing. And if we ever achieve the ideal of a stateless society where everyone is free and happy, I don't think that we'll really need to talk about the rule of law anymore, because then it will all be based on private property, self-interest. I'm not going to sign a contract with you if I think it goes against my interests, etc. Not to say there won't be a legal system, but I don't think there will be this thing we now understand as the rule of law. So I hope that somewhat answers that question. Yeah.
Concept of objective law, does that fall under the rule of law? Is it sort of its own thing, or?
I think there's an element of objective law underlying the rule of law, in that a law cannot just be based on transient political whims of the current ruling regime. There needs to be some constitutional imperative that's being given effect to. The Constitution is our highest law, and everything government does must be within the context of the Constitution and constitutionalism. And if it isn't, then it should be illegal. And I think we can't say the Constitution is objective, but I think that's probably the closest you can get, and that there needs to be a constitutional reason for whatever government does. And I think we see that that's mostly not the case. The Constitution, for example, and here comes the radical libertarian in me, does not say that government must micromanage how fast we drive on the highways, but yet it does. So something like that. Maybe the Constitution is badly written. I don't know. Maybe it should say that, but it doesn't. So, so government shouldn't do that. Any other questions?
Right. Somewhat abstract, and sorry if it doesn't make any sense.
I'm not a philosopher, so bear that in mind.
As far as an enabling environment to promote the rule of law, would you think that a codified constitution such as ours would be preferable or less preferable? Just an opinion-wise from your side, as an enabling environment to promote.
Yeah, no, I say it's absolutely preferable. I think the more certainty you can get from the law, the better. And when you have a right to freedom of expression, for instance, that says this is how hate speech is defined. If you go beyond this, it's not hate speech; it's protected speech. I think that's better than the British system, where Parliament gets together and under the limitation of democracy and popular participation, government can just enact whatever it wants, really, as a definition of hate speech, and the courts really have no choice but to give effect to that. I think to promote a real rule of law environment, you need to codify as much of the law as possible, ideally in the Constitution. Now, that doesn't matter, that does not mean that the rule of law is absent in the British constitutional system. The courts in Britain should also see the rule of law as, in their context, a fundamental pillar of common law. That's where the rule of law, I think, in many ways comes from, not necessarily British common law, but the jus commune, our interaction with each other, the nature of law, basically, means the rule of law needs to be adhered to. And there are jurists like Trevor Allen, I think he's at Oxford or Cambridge, currently who basically says parliamentary sovereignty is nonsense, our constitution is the rule of law, and Parliament needs to adhere to that. So, but you see, it gets very murky there. It gets very difficult to say, yeah, there's this thing that you can't really put your finger on that is the supreme law. In South Africa, it's easier because we have a supreme law, but we also have the incorporation of the rule of law, which means it's supposed to be so much stronger than it currently is regarded by our courts. So I hope that's abstract enough. Any other questions? Sure.
Would you consider social justice to be a good or bad concept?
Yeah, it's getting dangerous now. It's getting very dangerous. The way that social justice, I guess if we look at the ordinary meaning of words, social means relating to society, justice means each person must get their just desert, what they deserve. Yes, that's good, I agree. In society, people should get what they deserve, it should be based on their actions. Social justice has become, if it was a good idea, the political class has seen that idea, it has seized that idea and it's made it its own. It has turned social justice into a very tyrannical thing that now needs to be adhered to in every aspect of our lives. And it's getting absurd, all the things that are included in saying that what you're doing is socially unjust. Referring to someone in a way that they may not like, yes, you're an asshole, but does that mean in Justin Trudeau's social justice tribunals that you need to be levied with a fine, that you need to go to jail maybe? I don't think necessarily that assholes need to go to jail just for being assholes. I think that society can deal with it. If you are now, my fellow libertarians will probably lynch me for this. I don't have a problem with doxing, for example. I think if it's done privately, it's fine. You can say that person is an asshole, fire them. That's great. It's very, it's a peer pressure. What's the word we use? You're ostracizing that person. That's fine. That's something very consistent with liberal principles. But the moment you start saying the government must get involved, you're basically undermining your argument because you are saying that I came up with an idea, I think you're an asshole now, this needs to now become law and we'll use the force of the state against you. That's what the government tried to do with the first version of its hate speech bill. It said, now it's a very long definition of hate speech, but it basically said that if you ridicule someone or you attempt to bring them into contempt based on the job that they do or the beliefs that they hold, you're engaged in hate speech and you can be sentenced to jail for 5 years for a first offense, 10 years for any subsequent offense. So if you said lawyers are parasites, you're engaged in hate speech, you're going to go to jail for 5 years. If you said racists are idiots, you're insulting someone for their belief. You can go to jail for 5 years, up to 10 years, if you have a different government from this, obviously. So social justice, this is the result of contemporary social justice thinking. We think, not we, but social justice warriors, advocates, say that we think some things are bad, and that means government must now prohibit that. The law must prohibit it, and we must basically force everyone into our worldview. I think a lot of what they say is right. For instance, women have been conditioned over millennia. I think that's probably correct. That's right. But I don't think the government must now come in with its guns and its tanks and try to undo that. I think we as society probably have it within us to do that on our own. Yeah?
What if, like, as the sophistication of social media grows and it could be AI used to sort of further certain political agendas. What if technology like that is used to attack an individual person or really, really skew public opinion in a particular direction? So when it's not just individuals expressing their honest opinions or individuals having fights, but when it's on a much, much larger scale, but is essentially,
Geez. Yeah, that's a difficult question. So I'm not really clued up on AI, but in that case, I would probably still err on the side of no state action being taken, because so the anarchist Walter Block makes a very compelling argument, and that you have no right to other people's view of you. Your reputation is not something that you own. It is a view that other people have of you. There's something in their own mind. So if someone lies about you, sure, again, that's probably terrible. But again, you do not have, your reputation is not your property. You don't get to protect it by appealing to the state. You must then just make a better argument and say this is a lie. So in that regard, I think that even in that case, where social media is used by AI, I think there's a problem, but maybe not a problem for the state to deal with. Now, the other aspect of that is if it is a state, a government that is doing that, that is totally outside of the bounds of what I think the rule of law allows a government to do. What possible reason could a government have for engaging in such conduct? So in that case, I would say yes, a government can then stop another government from doing that. But when it comes to our ordinary interactions every day, by a day-to-day basis, I think no. Err on the side of just letting people sort it out amongst themselves.
I want to ask, how do you make liberal ideas popular in South African context? Because the conversation that we have in this room isn't very appealing to the majority of South Africans, or at least isn't well understood.
Mm-hmm.
So how do you make those ideas popular to, or at least consumable to everyday South African?
Yeah, so that is a very important question that I'm not sure I have the answer to. It's a very big question, but I think I think his name is Nicholas Taleb's view on this, and that is, it's not necessary to get everyone. You don't need your average person to agree with you. You need to create a substantial minority of people that agree with you, because I think any society, the ideas that govern that society is pushed by a substantial minority rather than a majority. I think the Institute of Race Relations has produced research time and time again showing that, in fact, most South African people, black, white, colored, Indian, don't want sport teams, for example, to be chosen on the basis of race. Yet that is what is happening, and the impression is created that that is what the people want. But in fact, it's a substantial minority, but it's a minority nonetheless, that has convinced the government, for lack of a better word, to pursue this line of action, and it's become entrenched. So as liberals, what we need to do is we need to create that substantial minority. That probably means we're not going to make this too digestible for our population, which is unfortunately quite not totally literate. It's going to be very difficult for me, for example, to talk about the rule of law to most South Africans. I'm sure you can make it digestible, but you're going to lose a lot of the necessary details along the way. But what I can do is I can convince the middle class about it. I can convince a lot of the lower classes, not all of them, and create. Hayek, he also has the theory of social change. We as intellectuals create the ideas that filters into the media, and the media makes it digestible for the common man. So again, you create a substantial minority of intellectuals, public intellectuals, thinkers, community leaders even, and they make it digestible. So we just need to come up with the right ideas. We need to make our ideas as appealing to the people around us, really, because as much as the word liberal is used today, I don't think most people are very liberal at all, even in the middle class. We often make the mistake of thinking, we have the middle class in our back pocket. We do not. If you look at, for example, a lot of Afrikaans people, like when I write an article in Afrikaans about free markets, and they're like, yeah, it's great. But then I write an article saying, no, government should not ban smoking. Then I'm the devil. So we do not have the middle class in our back pocket. We need to convince the middle class intellectuals, not necessarily converted intellectuals who are already authoritarians, but convince them that, listen, our ideas are better. Freedom is just better for society. Individual liberty just produces more prosperity, without exception wherever it is tried. Scandinavia, some of the freest markets in the world, prosperity, all around the world. So we need to convince our peers about that, and then it will filter down. So I think we create too big of a task for ourselves if we say we need to convince Joe everyman, because I don't think that can happen anywhere in the world, really.
May I say something?
Yes.
In response to the point that you were raising, that you've addressed quite adequately, Martin. And that is, I take it that you're talking about how to broaden the appeal of the basic, the fundamental classical liberal paradigm. That's what you're talking about. So you're trying to persuade people, you're trying to convince people, to take this seriously, and to internalize them, and to relate to the concept of classical liberalism. Let me tell you a brief story about myself. I try to be as brief as possible in terms of my modus operandi, pursuing along the lines that you're talking about. Now, my background is that of communism. I was a doctrinal communist. I became an anarchist, that kind of story. But it's been quite a long sort of ideological metamorphosis that I underwent to be where I am today. And so there were many people that I rubbed shoulders with during the time of the struggle against apartheid. I was never a member of any political party, but I come from the black consciousness background, still being my contemporary. So here I am at the Freeman Foundation, the first year, second year, and the people who come in and they say, Temple, how come? You are now with these capitalists, you are right-wing, that kind of stuff and so on. And whereas we used to attend and sometimes run, workshops on communism. One of the books that we studied being Das Kapital, and the one before that, which was Grundrisse, that had been written by Karl Marx. Not many communists know about that book. Then I would say to the person, okay, I'll tell you what, let's have a debate, let's have an interaction, but it's going to have to be mature, rational, and no ad hominem stuff, and you're free to engage me in whatever way. And they said, no, explain yourself. You are the one on the defense now, because you are now a reaction of, okay, fine, whatever label you throw at me, that is fine. I'll start by asking a couple of questions. Remember, when we were involved in the struggle against apartheid, what did we want in terms of education? Oh, we wanted to be able to go to whatever university, whatever schools we wanted to go to, and to be able to send our kids to schools of our choice, kind of stuff. Oh, that's interesting. But let's talk about work now. What kind of job, do you have a point about view on reservation, job reservation that we had in the context of apartheid in this country? Did we aspire to a situation where one could be free to look for whatever work one wanted, and without the government imposing any restriction? Oh yeah, of course, yes. Oh, that's even more interesting. And do you want this, that, and that? So I mentioned all these things. Now, this is being at the personal level. You want that person to get away from that gregarious sort of mindset, and the person to actually think on a personal, individual level. That's what you want to do. And so you raise all these points, and did we aspire to a situation where you could go to any hospital, for example, and buy the service or submit yourself to any hospital without the government saying to you, no, this hospital is for blacks or Bantus or non-whites and so on. No, we wanted everybody to have access to whatever hospital services were available, kind of stuff. So then I said, you know what? We had it all wrong, because our struggle, when we were prosecuting it, we were holding the flag of communism, which is antithetical to the answers that you have just provided. That's what I would say. Hey, comrade liberal, where have you been? I heard the guy thinking like this is right. Everything, all the answers that you have provided, they depict a classical liberal situation. And for that matter, Liberalism comes from the French root liberté, it means being free. And so the person will say, okay, wow, that makes me think. Now when you do that, this is how I would always do it. Remember my method has been Socratic, getting the answers from the person instead of imposing principles, imposing ideas on the person. And all those answers collectively depicting the classical liberal paradigm. And then I would say, okay, that's enough now. Because you don't want to alienate or embarrass the person. This is very important. You want that person to be able to follow up and not feel encumbered in terms of following up and pursuing the discussion where you had both left it off. And so I leave the person to marinate in that situation where the person feels, gosh, that was really quite something. Give it some time to cool off. And then follow up. The person doesn't follow up with the discussion. And remember again, to try not to alienate the person and not to expose them that they had it all wrong. And I would always say, look, you see, I had it wrong. I had it all wrong. I had read about the materialist conception of history, historical materialism, you can call it that, from the bowels of Marxism, but I had it wrong. And you know what I like about myself? It is because I've come to terms with the fact that I've been so naive. I'm saying that to this guy. I'm saying that. I'm saying I've come to terms with that, and I feel good about this because not that many people would acknowledge that they were wrong. So that's how I be able to get the person to move slowly to the other side. I hope you may possibly take a leaf out of the story that I just related.
I think to add to what Temba said, but to answer, the concept of the modernity of society for millennia now have been viewed from 1, 2, or 3 perspectives, not multiple perspectives, to have elevated vision and view of clarity of future. Now, this freedom we talk about, what freedom are we talking about? Freedom economically, freedom politically, freedom philosophically, freedom spiritually, freedom societally, psychologically, freedom what? And when one can start taking a perspective, a multiple perspective, an elevated vision perspective of multiple freedom, then the pursuit of liberty can become true pursuit of liberty. And the concept of modernity applies because we want to create wealth. Wealth is not a concept of distributed, it's created. We men create wealth. Education must be extensive. Justice must be inclusive and extensive. Power must allow for it to be constructive rather than destructive. And if we can give people this multi-perspective of what freedom is, then I have found that, like Temba, knowledgeable others through social engagement help me to unfreeze perspectives. I think the problem of the pursuit of liberty is that there are frozen perspectives on 1 or 2 or 3 different disciplinary approaches or views to that freedom, and that prevents true liberty. Does that make sense what I'm saying? But my question to you, Martin, is the Constitution, the rule of law, 2 disciplines that we're examining in the move to the light of man. What are the key high-level constructs that we have to consider that we might get to this better way of being, this modernity of man?
So you mean ideas that we need to accept to get there?
Yeah.
Well, geez, I think freedom is good. Is probably a good start. And I mean, you just very adequately described that there are many different levels, ways of conceiving of freedom. But as a general political rule, economic, civil issue, I think And I think most people are already there. I think, as Temba very greatly explained now, if you really sit an individual down and you basically just try to get out of them, hey, do you as a person want to be free? The answer will invariably be yes. So I think most people are already over that line. We just need to help them understand what it is they actually believe. And then, of course, limited government. I think people need to accept that you can only have freedom with a limited government. Or if we push them way over the line to no government, that's also okay. I don't mind. But as long as they understand that government is not the solution to their problems, and government's role, if any, needs to be limited. Yeah, I'm not that much of an abstract thinker. I don't know what other ideas really there are on the way to attaining the light. I just think we've already accepted the premise. I think most people, when you ask them, geez, government is acting wrong, what should they do? They'll say they must adhere to the Constitution. So we already have them buying into the premise. All we need to really do is say, well, okay, this is the Constitution. This is what it actually says. Moseneke and Mogoeng are good guys, but they're wrong on some things. And we need to rectify that. And I think most people have bought the premise. And I think if we can convince them that the courts just have got it wrong, government has got it wrong, and I think most people agree government has got it wrong on many things, then we're halfway there, I think. You know. Anyone else? No? All right. Again, thank you for coming. I think there are still a few snacks and drinks at the back. Please help yourself. And if you want, the books are right there. If you want to buy one, if you want me to sign it for you, I am here. So thank you.